Hello, I'm Mark Pollitt, and welcome to a short presentation on federal laws. In this presentation, we're going to be talking about a number of different federal laws. I am going to discuss state laws at the very end, but the reason that we're going to focus on federal laws is because in information technology, we very often operate in an interstate environment, and as a result, there's several bodies of federal law that will control what it is that we're doing. That's not to say that there are not state laws that control as well, but as I say, we'll talk about that later in the presentation. There are essentially three flavors of law in the federal system. One is criminal, and criminal law is where we are punishing a behavior on behalf of society. It includes the traditional things like murder, rape, etc., but it also includes crimes that are unique to the federal system, such as interstate commerce crimes, as well as crimes against the federal government itself. And those are the crimes for which we arrest people and put people in jail. The next body of law is civil law, and it basically regulates behavior between individuals, organizations, and between governments and their citizens other than of a criminal nature. And civil laws are designed essentially to help regulate our relationship with each other. Regulatory law, on the other hand, is a kind of hybrid body of law. It is authorized by statute. Congress basically gives the authority to, for instance, the FAA to regulate air transportation. And so the FAA then comes up with a series of regulations. And in that particular case, they're called the Federal Air Regulations. And there's a notice of proposed rulemaking that goes into creating them and then updating them. And it becomes an entire body of law based entirely on a regulation that was not enacted by a deliberative body such as Congress. But nonetheless, it has teeth. It can result in punitive fines or inability to do your job. Now, as I mentioned before, federal criminal law applies in what's called the federal jurisdiction. And federal jurisdiction can be achieved in one of several ways. There are some physical locations that are inherently federal territory. And an obvious example might be something like the White House or the Capitol building. Those are entities that do not actually reside in non-federal jurisdiction as a matter of law. More and more, those are kind of going away. There's very few locations left that are strictly federal jurisdiction. But one particular class of federal jurisdiction is truly unique to the federal government. It's called the Special Territorial and Maritime Jurisdiction of the United States. And it includes things like aboard U.S. flag vessels or U.S. aircraft operating in international waters. There are no state laws out there, so the only jurisdiction is federal. There's also jurisdiction we call constitutional jurisdiction, and this is jurisdiction that has been given to law enforcement by the court system or by the Constitution through various aspects of what the Constitution regulates. What I mean by that, and the most common one, is the Interstate Commerce Clause of the Constitution. And using that Interstate Commerce Clause, Congress has passed a large number of criminal statutes that basically say this behavior is wrong if it either is in interstate commerce or affects interstate commerce. And so that is a constitutional jurisdiction. Likewise, the creation of the military and having a uniform code of military justice is a constitutional jurisdiction. The Constitution gives the federal government the right to A, be the only folks that do national defense, and B, to create a system of jurisprudence in order to regulate that military. But in any case, all of them are designed to protect society, not individuals, but society as a whole. And in criminal cases, the government is always the complainant. While you can be a victim in criminal law, technically it is the government that is the complainant. And interestingly enough, most people don't think about it, but corporations are individuals under the eyes of the law. And so corporations can be held criminally liable just like individuals can. And while it's difficult to arrest a company, you can actually fine companies and also seize property from them. So they are subject to criminal law as well. The federal statutes are arranged by title, which is actually a fancy name for a book or a volume. And the majority of the federal criminal statutes are under Title 18. There are criminal statutes sprinkled throughout the rest of the federal code, as it's called. Most notably in Title 21 are all the drug offenses, and all the customs offenses are in Title 19. They're obviously arranged in numerical sequence, but they're not necessarily logical because it's been edited and changed and updated and amended over the years. So you pretty much have to look it up by topic and by statute number rather than trying to just go through the table of contents. At any rate, it includes the typical crimes, and by these we mean the things that you most often think of as crimes, things like homicides and burglaries and some frauds. And those typical crimes are usually only prosecutable under federal law if they occur in the special territorial and maritime jurisdiction of the United States. If they happen on the street, a homicide in the middle of downtown Orlando is not a federal crime. It is a state crime. But if a homicide occurs on a U.S. flagged vessel 50 miles offshore, then it is a federal crime because it is in the special territorial and maritime jurisdiction of the United States. And as I said before, it also includes interstate crimes, like the interstate transportation of a minor across state lines, as one example of physical interstate crime, whereas something like extortion has to impact interstate commerce, which in this day and age is not very hard. And then last but not least, there are the crimes such as theft of government property, which is a crime against the government itself. There's a number of other statutes that really focus on areas that we need to think about in terms of our information security. The first group is the protection of trade secrets, and there's actually two statutes here. And one of them is 18 U.S.C. 1831, which is the Economic Espionage Act, and its companion piece, the Theft of Trade Secrets Act, 18 U.S.C. 1832. The former one is designed essentially to punish individuals and organizations for utilizing trade secrets or stealing trade secrets to benefit a country or a foreign organization. It is, in effect, applying espionage in the traditional sense against intellectual property owned by the private sector. This became a real issue back in the 1980s and continues to this day because the United States has invested a great deal of money in research and development and technologies, etc. And if a foreign country can pay a relatively small amount, steal that information, and then make use of it for their economic benefit, we lose, the American taxpayer loses, the company loses, and everybody except the foreign country loses. And so in order to punish this, they created this economic espionage statute. And notice that it goes from cradle to grave. Everything from getting the stuff, transferring it, selling it, or merely possessing it for the benefit of a foreign organization can get you 15 years in a federal penitentiary, a $500,000 fine, and if you're an organization or a corporation that did this, a $10 million fine for organizations. Now, if you merely steal trade secrets not for the benefit of a foreign entity, then you only get 10 years in jail, and you can get a $5 million fine for an organization. There are a surprisingly large number of prosecutions under the statute, considering the very narrow drafting of it. One of the most important statutes that IT professionals really have to be familiar with is the Electronic Communications Privacy Act, or ECPA. And it really has a number of different sections, each of which has its own sub-definitions or subdivisions. And I'm going to go through them sort of briefly, but it's a large body of law, and it's a body of law that has changed on a fairly frequent basis, particularly since 9/11, and so you really need to get current legal advice on this. Because, as I put in my disclaimer, the information here is accurate as when I provided the lecture, but it very well may change by the time you see it. 2510 provides a whole lot of definitions, and it defines what a wire communication is, it defines what oral communication is, and it defines what an electronic communication is. And the reason that it breaks it down this way is fairly historical. The first wiretap statutes were really done literally for listening devices, and then to be able to listen to phone conversations, and then to be able to get phone switching information, and what level of protection does the actual oral communication have versus the electronic part of it. And so they've adapted these over the years to the new technology, and it has been a very difficult problem trying to keep the statutes updated with the technologies. And as a lot of the technologies have started to really coalesce, they're really the abstractions of oral and electronic really kind of pale. So. One of the statutes, one of the definitions talks about readily accessible to the public, and this is really kind of interesting, particularly as it comes to wireless, like Wi-Fi. That pretty much, if people can hear it and it's not encrypted and it's not in some other way, shape, or form hidden from the public, then it is readily accessible to the public and may be accessed without penalty. So the moral of that story is, if you want to keep anything private, the statute in effect tells you, look, you have to encrypt the stuff, or you have to use some technique that's going to make it difficult for the public to get access to it. There's a section on 2510 that defines a protected computer. And what it does is it adopts the definition in Section 1030, which is the Computer Fraud and Abuse Act, which we'll talk about here in a little bit. And so as they update 1030, that has updated the 2510 definitions by reference. There's another section in there that talks about what a computer trespasser is. And this was something that really kind of evolved in the 90s. We understood that there were people that would go into computer systems not necessarily to do anything, but they were there and they weren't supposed to be there, and what rights did they have once they were there. So 2510 defined a trespasser is somebody who accesses a protected computer, which is another definition out of 1030, or is that definition out of 1030, without authorization, and therefore has no expectation of privacy. And that's really important, because most of the rest of the statute will talk about what a reasonable expectation of privacy is. And the assumption is that if you are lawfully there, then you have a reasonable expectation of privacy, whereas the statute here defines a computer trespasser as someone who has no reasonable expectation of privacy because they're not supposed to be there. And like a lot of the things in the Electronic Communications Privacy Act, there are some exceptions to that, which you can see on the screen. 2511 is the guts of this, and is often known as the wiretap statute. And it talks about the interception disclosure of wire, oral, or electronic communications. and again, those three terms of art that we talked about earlier. And basically, it says you can't access somebody's oral wire or electronic communications except by exception. And it outlines those in there, but I'm not going to go into them in great detail, but essentially wiretapping is illegal in the federal system unless you are one of those exceptions. And that if you obtain that information, whether you listened to it or somebody else listened to it and gave it to you, and you disclose what you heard to anyone else, you are in violation of the statute, with the exception of service providers and law enforcement officers pursuant to an authorized criminal investigation. And this is part of that exception. It's not unlawful for the operator, employer, agent of a provider to disclose this information in the normal course of their employment, which is necessary incident to the rendition of the service. In other words, only to the extent that they have to use that information in order to maintain service. And where this came from was literally the phone company used to have employees to measure the quality of service by listening to conversations, and in the course of that, of course, they would hear what was on those conversations, and this basically prohibited them from telling anybody else what they heard. It allowed them to hear it, but it prohibited them from disclosing that information. That was the origin of this part of the statute. And here's where you get into this reasonably accessible to the general public, or readily accessible to the general public, is that if it isn't readily accessible, then it's a violation. Or if it is readily accessible, then it may be an exception. It also says that you can't listen to these communications as a law enforcement person or under the color of law, as it describes it, if you're doing it unless you're doing it from the perspective of an owner operator or a lawfully engaged lawful investigation, and whatever other requirements which are going to be put forth further down the statute on these. And then there's a separate section, and again, there's an interesting historical background for why it's a separate statute, but they recognize that electronic communications may actually be stored either as sound, like a voicemail, or as text messages, or even the metadata of the communication is going to be stored, sometimes very shortly, sometimes for long periods of time. And so they developed the Stored Communications Act, 2701, which basically says you can't access stored communications except in a number of exceptions. Again, if you're the provider of the service, if you're a user, you can do it, or as a law enforcement officer with the appropriate legal paperwork. And speaking of which, the 27034, etc. outline, as well as 2711, outline the ways in which you can obtain access to this information. One of which is consent of the user. Another is by subpoena, and there are some things that you can subpoena and other things that you can't. There's a thing called a national security letter, and there are things that you can get with regard to that and things that you can't. You can get a court order or a search warrant for almost anything, as long as you can articulate where and what the statute is that's being violated. I don't go in any great detail on this because this is an area that's constantly changing, and quite frankly, it's a little tricky. So I strongly suggest that if you are asked to provide some information that you think may be protected under the Electronic Communications Privacy Act or the Stored Communications Act, that you seek legal counsel before you comply with any request. Another interesting part of the overall statute goes back up to 2703, and that is that if the government comes to you and says you need to preserve this evidence, then you have a duty to do so. And if they ask for a period of retention for you to keep it for a certain period of time, you're required to do so. And it's outlined on this slide. We're going to move on to what the trader called the substantive statutes, which are the actual crimes. The first one is 1029, which is fraud and related activity in connection with access devices. Again, it's got a very interesting history. The statute was originally developed to protect the phone companies from individuals that were doing blue boxing, black boxing, red boxing, basically using tone generators to get access to the telephone service back in the days where long distance actually cost money. And so the original intent was to punish the use of these devices as well as prevent the sale and distribution of devices that would allow you to do that. And so the statute says knowingly and intent to defraud produces, uses, or traffics an access device. Well, after a while, the phone companies quit using tones for their switching purposes, but they started to use codes, and particularly in the early days, very often access codes. And so the law adapted to that to allow the trafficking in those access codes to become a crime. And of course now the primary access device is a credit card. And so this is actually the statute that the Secret Service uses to enforce a great deal of their credit card fraud cases. And they are, in fact, the primary have primary responsibility for this particular statute. The statute that next came out was 1030, which is the Computer Fraud and Abuse Act. And this has gone through numerous revisions. It originally was 4 sections, then it was 5, and now it's 7 sections. And those sections keep changing and the exceptions keep changing. So again, this is one of those that you want to get some current advice on. But just generally, Section 1 is often referred to as the Computer Espionage Act. It basically proscribes, prevents people or prohibits people from acquiring information that's classified in nature, either national security information, atomic energy information, and that sort of thing, to a foreign government. And it's a very strict statute, and it very strongly parallels the espionage statute. Ironically, it parallels it so well that it's almost impossible to prosecute. And I don't think there's been a prosecution under 1030A1 that I know of, but it's a very hard statute to prove, which can equally be charged under other statutes. They moved financial records into that group as well under A2, and that part is very similar to the 1029 statute, and so as a result, sometimes you can the same conduct could violate 1029 and 1030A2. And then the B and C is information either belonging to an agency or department of the United States government, or from a protected or from a protected computer, which the statute will tell you what it is shortly. And then 3 is the computer trespass statute. Basically, it's anybody that goes there and does something and that use interferes with the use of the government's use of it, then you're in violation of that. 4 is the kind of the most common and big gun on this, and that is what's called the computer fraud part of it. And basically, if you use a computer to commit a fraud, then it's it's a violation of A4. And then 5 is the what I refer to as the hacker statute. It basically is the transmission of any code that will result in damage damage to a computer for which you don't have authorization or is defined as a protected computer. So that statute is kind of broken down into several parts too. There's a time aspect of it. There's a value aspect of it. It has to do $5,000 worth of damage, and or have physical injury or death to someone as a threat to public health or safety, or will interfere with the administration of justice, national defense, or national security. So there's enhancements for those that do bad things to government computers. And then just to make sure that we have all access devices covered in 1030-6, it has the password and access device statute as well. And so very often that will be charged under 1030 rather than 1029. And that's one of the more important computer crime statutes. I want to talk a little bit about some of the civil liabilities, and I teach these in a lot greater depth in one of my other classes. But it's important to understand that there's a federal statute, the very first one for protection of privacy is the Health Insurance Portability and Accountability Act, or HIPAA, and by the way, it's Privacy and Portability Act. And it defines what is private information as health information, things like your name, date of birth, and all those sorts of things. And it mandates anybody that has protected health information, or PHI for short, to utilize certain security measures. As a result of a lot of the corporate failures in at the turn of the millennia, they came out with the Gramm-Leach-Bliley Act, which basically not only limits the sharing of data with third parties, but again, it requires that you have security in place and that you can protect that information. So that's GIBLA or Gramm-Leach-Bliley. Sarbanes-Oxley is similar in that it came out of the ashes of the failed corporations, but it has a couple things that it says, one of which is that the CEO and the CFO personally are responsible for the security of information and for annually certifying that information with respect to their corporate filings. And what this has essentially done is forced public corporations to have accountability with regard to the information that they keep and they provide, and in turn, from an information security perspective, it requires them to tell us what security processes that they have and that they've tested them and that they work. California was the first state, and now a lot of states have done it, have created a Consumer Information Breach Act. And you see a link on the screen for places where you can get, or you can find that statute in detail. But each state has these. California was a really big deal because not only were they the first to do it, the way California defines a California corporation is any corporation that does business in California. And so even if you're located in Ames, Iowa, if you do business in California, California says that you have to comply with this statute. And how enforceable it is in Ames, Iowa, I don't know, but certainly if Ames, or if Iowa has a similar statute, then California may ask the Iowa Attorney General to prosecute under Iowa's law. So it really was the precursor and a big gun, and it forces corporations to protect their consumer information a lot better. There's a thing called FISMA, the Federal Information Security Management Act, and it's been changed every couple of years since the 1990s, I think. And why it's important is that it provides in the federal system for all federal agencies, which is a huge variety of organizations, that they have to have a framework for information security, and it requires them to have minimum controls. It provides a structure for oversight of security programs. And from the private sector's perspective, what's best is that it says, the private sector can usually provide a solution cheaper than the government can write their own software or build their own hardware. And so it requires market solutions wherever feasible. Obviously, in some areas like encryption, that may not be possible, but for most things, market solutions generally work well. I'm only going to spend a minute here talking about state laws. Every single state, I think, now has a computer fraud and abuse statute, and many of them also have wiretap statutes as well. And so you need to find out what statutes are available in your particular state or are required in your particular state. And in this particular case, I found this one website on online security that lists all of the computer crime statutes by state and provides links. You can see down the bottom that Florida has a very robust Computer Crime Act. In fact, it was one of the first. But you need to know the state laws where you are. As an example, in Florida, it's a two-party consent state, meaning that one person alone cannot consent to the recording of a conversation. So where in two-party states or in the federal system, as long as I get one person to agree, I can record the conversation surreptitiously. In Florida, you cannot do that without committing a felony. So you need to know these sorts of things if you're going to be monitoring systems. And that's it for this very short presentation. And until next time, have a good day.